I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms. Leaf.
This is disgusting, but it's all starting to make sense. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's offensive. And it's not your fault, Judge. Steam's been coming off my bald head all night. Nothing about this is okay.
I call that video Mad Max because he is mad, and with good reason. And welcome back Inside the Law, folks. I'm your host, Philip Holloway. This is the LawTube channel where we're going to take you inside the real justice system to show you what it's really like in real courtrooms all across America. So there's a lot going on in this Fani Willis versus Young Thug trial that we're going to get into today. In a few minutes, our friend Rachel Kauffman is going to help me to break it all down. All right, what happened today? Well, among other things, the lawyers are pissed. Well, what are they pissed about? They are pissed because last night they found out that there was another ex parte conversation between the prosecutors in this case and former trial judge Glanville. Glanville was ordered to be recused. Initially, he resisted it. He basically flat out said, I'm not going to recuse myself, even though Georgia law requires a motion to recuse to go to another judge. You can't grade your own papers. If the lawyers say you're doing something shady, you need to be recused, another judge is supposed to look at it, but he failed to do that. Our friend Doug Weinstein, who's the author of this supplemental motion for mistrial that you see on your screen here, Doug went to the Supreme Court of Georgia, and Doug said, look, I want an order from this court ordering this man to follow the law, to send the recusal to another judge to consider. Long story short, the Supreme Court did not agree to do that, but in denying Doug's request, they gave some interesting instructions on what needed to happen nevertheless, and eventually got Judge Glanville to reverse course. He sent the recusal motion to another judge who said, well, maybe the ex parte is okay, maybe it's not, I'm really not sure, but I'm going to recuse Judge Glanville because he didn't follow the right process. So they kind of punted on it, but nevertheless, we have a new judge. And so now we've got all these motions for mistrial. And yesterday, a lot of them were argued. Today, the motions for mistrial, except for Doug's, the one that you see, or at least part of the one that you see here on the screen, is still under advisement. So we're going to take just a minute and take a look at that. Before I do that, I want to bring in our good friend Rachel Kauffman, who was actually, I think, in the courtroom some today at the courthouse following all this. And let's big round of applause for our friend Rachel Kauffman. Rachel.
Hello, Phil. Yeah, it was a wild day in court. It ended early, but we'll get to everything.
I want to take just a minute and I want to go through. I'm not going to get it. You've got the transcript. So I'll save the highlights of the transcript for you with the exception of the ones that Doug put in this supplemental motion for mistrial. And so here's what Doug says. Okay. Doug points out that outside agitator is a term that delegitimizes internal dissent against the status quo. So anyone who speaks up against the status quo, whatever that is by definition an outsider. And he's citing a professor from Berkeley. One thing that I love about Doug's writing, and Doug is, as he'll tell you, he's relatively new to criminal law. He's done a lot of civil litigation. Doug likes to be creative in these things, and he cites non-traditional sources to get his point across. And he goes on to say, Judge Glanville making outrageous allegations against members of the defense teams in the present case, quote, but I think it does in some way outside agitators and everybody else who I think are trying to influence. So this is a quote from apparently Judge Glanville. Now this, by the way, the ex parte that was revealed was from the Friday before Woody, Mr. Copeland, it was on the Friday before the ex parte that we knew about. It was the first day they had Woody there in court. He points out the third ground argued in Kendrick's motion for mistrial, Kendrick being Doug's client. It says due process rights were violated relating to the 14th Amendment, due process relating in part to Judge Glanville wrongfully coercing witness Copeland to testify. Further evidence of the state and Judge Glanville's violation of Kendrick's due process has just come to light. This is what Max was so mad about. And Max is right about that. This is not about anybody's guilt or innocence. This is about fairness in the process. What Doug is pointing out, what Max was talking about there in that video is, the judge being not fair and not impartial. And he says yesterday after court, Kendrick received a rough transcript, Exhibit A, of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7th, 2024. The rough transcript was helpfully provided by this court. That means the new judge, right? The new judge handed it over to defense counsel, as she should, by the way. It's refreshing that judges will, do the right thing. She comes across, oh my gosh, there's this other one. Let's go ahead and hand this over to the defense, and we need to deal with this one as well. A reading of the rough transcript highlights that which has been obvious to all observers, except for Kendrick's counsel for the past 19 months. Now, what does he mean? It's been obvious to everybody except himself for the past 19 months. Well, I'll let Doug speak for himself. This is what Doug is talking about.
What I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him, and now I have been made to look like an idiot.
So that's what Doug is talking about. He says, apparently everybody saw it but me, and now it feels like an idiot. I think if truth be told, Doug probably saw it too, but he's self-deprecating in that way. Glanville has been willfully biased and acting as a member of the prosecution team since the inception of the case. Kendrick's counsel takes no pleasure in alerting this honorable court to the situation, but obligations to the client require it due process, and a fair trial requires it. It's not a fair trial when in an ex parte meeting, Glanville, prosecutors Love and Hilton gossip like yentas. Anybody know what a yenta is? Tell me in the chat. I don't know what a yenta is.
It's Yiddish for like a gossip.
Oh, okay. It's Yiddish, you say?
It is Yiddish, correct.
All right. So I didn't see. I learned. We were here to learn, and even I learn stuff all the time. All right. So they gossip like yentas over 13 pages of transcript about attorneys Sharp, Melnick, and Steele. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton assassinate the character of attorney John Melnick, attack his integrity, alleging that he is not acting in the best interests of his client, Mr. Copeland. And it's not a fair trial when, in an ex parte meeting, Glanville, Love, and Hilton attack attorney Bumpus for allegedly hugging Kendrick and stating that she is incapable of representing Copeland. It is not a fair trial when, in an ex parte meeting, Love lies to Glanville about an email she received from attorney Melnick. Now, in case you are just getting up to speed, there is no love lost between attorney Melnick, who formerly used to represent Woody, and prosecutor Love. So he is upset too, and they're apparently, according to this new filing, they're talking about him in this newly revealed ex parte. And he goes on to say it's not a fair trial when, in an ex parte meeting, Glanville starts talking about outside agitators, stating, my comments today were predicated on there's a lot of stuff that's going on in the background, and it shouldn't have anything to do with y'all's case. It really shouldn't, but I think it does in some ways, outside agitators. Now, so here, think about this. This is in the judge's chambers or somewhere not in the courtroom, and you got the trial judge talking with the two prosecutors and nobody else, talking to them about the comments that he made in court. So he's talking about the substantive proceedings that went on in court. I can't begin to tell you, in my opinion, how unlawful and improper and unethical that is. It is not a fair trial when, in an ex parte meeting, Glanville and Love have the following outrageous conversation. The court, but I think it does in some way outside agitators. Miss Love, that too. And then the court says, and everybody else who I think are trying to influence. Miss Love says that's absolutely happening. It's not a fair trial when Glanville, Love, and Hilton have this further discussion. Hilton says there's a lot going on. Miss Love says there is a presence. Yes, yes, that is all I'll say. The court, I mean, I see it, but just from being in the courtroom and tracking. Doug asks, how many violations of the Code of Judicial Conduct does it take to get a mistrial with prejudice? This is like an old house that the present honorable judge is tasked with renovating. Every time a piece of pasted up wallpaper is removed and more rot is found underneath. No Herculean effort by this court can fix the due process violations of the last judge. This house must be torn down. I love this colorful language. A mistrial should be declared and retrial barred due to prosecutorial and judicial misconduct that has goaded Kendrick into the present motion. And we've talked about this word goaded. It's a legal term of art. If the defense is basically forced into asking for a mistrial by prosecutors, or in this case, the prosecutors and the judge, then there would be no retrial due to the double jeopardy clause. He goes on to ask the judge to declare a mistrial based on at least the due process violations of Kendrick's constitutional rights under the Constitution of the United States, Constitution of the State of Georgia, and attaches the rough transcript that was given to the parties, I guess, by the judge last night. Rachel, what do you say?
So really quick, I want to say that, like Doug, I mean, I feel like I've defended Judge Glanville because I've had experiences with him where I didn't realize or didn't see these kind of ex parte communications, and I would kind of like excuse some of his behavior. Like I couldn't believe it. When I read this transcript, I was shocked. I feel like there needs to be like a search warrant of Adrienne Love's phone. I want to know the text messages that went back and forth between her and Glanville throughout this trial. I don't believe that this is it. This is what was caught by a court reporter.
Now, do you think, is there something in this transcript that leads you to believe that there's those kind of texts and things going on?
The familiarity with which they're kind of discussing as a team, like they're huddling to come up with ways to get around certain aspects of the case. One being that Copeland was represented at the time that Miss Hilton approached him and started basically threatening him into testifying, or else he would be in jail.
Lawyers, by the way, we're not supposed to talk to a person if we know that they're represented by another attorney. We're supposed to contact that attorney. So the prosecutors aren't supposed to be talking, even with a subpoenaed witness. If they're represented by counsel, the prosecutors are not supposed to talk to them without going through the lawyer.
As I'm reading through this transcript, basically they start saying that it was actually Copeland's obligation to formally tell the prosecutors that he was represented and didn't want to talk to them. I don't know whether that happened, but I do know that Melnick reached out to them and let them know that Copeland was represented by him. One thing that really bothers me is how they're gossiping with the judge, these prosecutors, Hilton and Love, about how some of these witnesses are being represented by individuals who they think are like seeking out the fame of representing. I mean, it's absolutely ridiculous talking about how like they're trying to beat outside influences. And the judge is like, yeah, I see it too. Just not respecting the fact that witnesses can and are in fact represented. Trying to find any way for them to influence Copeland into testifying without counsel present, claiming that they're concerned about the counsel that he has. My favorite, I mean, we can go through the whole thing. It's just, so Miss Love says, Mr. Melnick told me previously that he was not representing him. I have no reason to believe that that's true, especially because Melnick got up there and said that, you know, Adrienne was a liar. And I believe him because she is a liar. The court said, this
is all the part of the conversation that's going on in chambers without the defense knowing about it.
This is shocking to me. The judge, back to Ms. Love, says you would not speak to an unrepresented party. I mean, I know you know enough of the rules to know that if you thought or intimated that somebody was represented by counsel, you would go ahead and let them contact their lawyer. And Ms. Hilton, it's like, I don't know, like Tweedledee and Tweedledum. Whatever Adrienne says, Simone Ms. Hilton just kind of repeats. Mr. Copeland would have said, because I don't know as a witness and he's not charged. So now they're saying that because he's not charged, they didn't know.
So they're having this discussion with the judge about why they may or may not have gone through his lawyer.
All the reasons that they didn't, including that Copeland wasn't a defendant. So they didn't know because his lawyer hadn't filed an entry because there's no case to file an entry in. One of them claims that actually that Melnick told Ms. Love that he actually wasn't representing him, which is not true. And then she says, we would have left. Okay. She said, because people counsel that they have under retainer or something. So you can be, I represent some of the wives and girlfriends of defendants in this case. So, hey, I have a lawyer that I use for everything and I want to talk to him. I'm not comfortable talking with you unless my lawyer is present. So now they're basically saying that he has to specifically plead the fifth, even though these prosecutors know that he's represented. And that's kind of neither here nor there because they have ethical duties as well. But again, we're just here gossiping about what everybody else is doing wrong.
Well, in case anybody wonders, why this is a problem, this is what the Georgia law says about ex parte communications. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or an impending matter subject to the following exceptions. And then it goes on to talk about scheduling, administrative purposes, emergencies that don't deal with substantive matters, and so on and so forth.
And also, when the reason believed that that one of the parties wouldn't gain a tactical advantage by the ex parte communication, and here they're actually like huddling together to figure out how they're going to get a very reluctant witness to testify. So it's Adrian lying, Moore lying, and then Ms. Hilton explained to him at length that whatever happened that he did in 2015, which is all we're going to be talking about with him, the statute of limitations has run. He didn't do the murder. We know that. Okay, I actually, if anybody, you don't have to be a lawyer to know that the statute of limitations on a murder, there is none.
There is no statute of limitations on a
To
murder.
claim that that the statute of limitations has run.
Yeah,
he didn't do the murder.
That's horse shit.
I mean, that's a lie. I mean, these are lawyers talking about this because I believe that Mr. Copeland at some point said, I did all this. And so they're saying that we don't believe you, even if you did. They take issue with the fact that I guess Miss Bumpus knows some of these defendants. I do too. If I could hug Young Thug, I would go in and hug him. Why not? But it says, I believe in conveying to the court that Miss Bumpus is going to take stand in his stead, meaning replace Melnick. And she was, what is the word I'm looking for? The sheriff had to speak to her because she was in the room trying to hug Jeffrey Williams. Miss Hilton says no.
So they're literally in the judge's office or wherever. They're not in the courtroom. They're talking about all the things that are going on related to the case in the courtroom, out of the courtroom. There's nothing, in my opinion, I can't find anything proper that would justify this kind of ex parte carryings on.
Miss Hilton corrects her. Yeah, she hugged DeMonte, and Miss Love said, oh, I'm sorry. In fact, she hugged DeMonte and hugged Mr. Williams. And that's how Captain Kendall, who I believe is probably one of the sheriffs, saw her and had her taken out. So then Miss Love says, she starts talking about how she's expressing concern that Mr. Copeland, all of a sudden they're concerned that Mr. Copeland's interests aren't being properly represented since they have his best interest in heart. I mean, I find that so despicable for them to be now saying that the people representing him, we don't like how they're doing it. We don't really even accept the fact that they are because we're trying to go around them. And they're not actually, it is, she's half German Shepherd, half Bloodhound, Cheryl. So yeah, she just can't be quiet. But anyway.
Well, you know what you do if you've got this real, if it's a real concern, you file a motion to disqualify the lawyer. You have a hearing on it in open court where everybody's there.
And then you kind of go down and she says, Mr. Copeland has been reaching out to Ms. Hilton and that communication is being blocked by someone who Mr. Copeland didn't reach out to. So again, they're taking issue now, these two prosecutors. It's not their business how a witness comes to be represented. He's represented. So at first it's that we don't think that they're acting in their best interest. Oh, they actually sought out Mr. Copeland. And she said, no, you notice no one said Mr. Copeland called me. I mean, why would I have to explain to the court how I came to represent a client? He never said, when we put on the record what Ms. Hilton had said. The way I understand it, Mr. Melnick reached out to Mr. Copeland because the first time the first time we heard the assertion that, oh, he's going to plead the fifth, it was when Mr. Melnick sent an email to Miss Hilton, myself, and copied Mr. Steele and Mr. Shard. And then again, the court gets in. It's like he's just part of the gossiping crowd. Why would he have done that given? And that's the state's concern, says Ms. Hilton.
All right. Well, so this is ADA, Assistant DA Love. And for those of you who may have missed the intro to the show yesterday, this prosecutor got it handed to her by the judge related to her duty of candor to the court. All lawyers have an obligation to be candid and truthful. Basically, that's what that means. Truthful with the court at all times.
Yeah. And so this continues about how they're talking about if Mr. Melnick, he says, what he did was he looked over at two people and said, I did what I could. Their concern, apparently, Miss Love and Miss Hilton, is that somehow through John Melnick and Kayla Bumpus, that the defendants are influencing Copeland not to testify. They haven't threatened him at all. Meanwhile, Hilton and Love are threatening him with being in jail till all the 26 people are tried. Okay, the court says, well, there's a lot of innuendo. They have asserted themselves. They, being some of the defense counsel, have inserted themselves in this particular process. And then Ms. Love says, well, that's my concern with Mr. Melnick's insertion of himself. Judge responds to her, what are you asking me to do? What are you asking me to do? And what do you think I can do? Why are they teaming up to do this? Here we go.
Well, why isn't this a motion being heard in open court?
It's not even a motion. It's just complaining.
I know, but if you have this concern, you file a motion to disqualify. Maybe you talk to the lawyer first, and if you can't work it out, you file a motion to have him recused or you have him taken off the case due to a conflict of interest, if you believe you. But you have a hearing in open court and let him present evidence or testimony, and you let the other people involved in this trial, namely all of the defendants and their lawyers, you do this all out in the open. I mean, this is not a medieval star chamber. At least it's not supposed to be.
It is. And so please read the next part because I can't handle it.
Okay, Ms. Love, that's the exercise. That is the homework for tonight. I wanted to give the judge homework. I wanted to let the court know that that's what we're looking into right now, because there is a remedy, because I have faith in our law. I love this thing. There's a remedy, because this can never have been the first time that's happened. It has been addressed. I just have to find it. Yeah, it's called a motion to disqualify the lawyer for a conflict of interest. If you think that's what's going, if you got evidence and you can prove it. Anyway, she goes on to say, but I didn't want to be looking for something and not let the court know what I'm looking for. Well, why not? Do you share everything that you do with the court? All right. What I'm looking for, so that you are not caught off guard, Judge, when Monday morning or Saturday night or Saturday afternoon, we find it and we send it to you. Are they having ex parte emails or texts, or what's going on the weekends, Rachel?
It's so hard for me to say this because I didn't realize that Judge Glanville was so entrenched with Miss Love, but the fact that he's saying to her, what are you asking me to do? What are you asking me to do? And what do you think I can do, without the defense present to argue what he should do? But what I wanted to say is that the judge specifically asked how many ex parte meetings were there yesterday in court. And she asked the defense how many they've had and like what was the context, asked the state. This June 7th transcript that occurred before the other one that was released about with Kayla Bumpus and Copeland and the judge, the state did not mention this yesterday, even though clearly it happened. It's another lack of candor to the court, just unbelievable lying. And so when she starts talking about how proper it is to keep them on the case and how nothing that they did was wrong, lying to the court, that they have a lack of a lack of candor when they have a duty to actually be truthful to the court. The judge specifically asked about all the different ex parte meetings that had been had that might be of interest to the opposing party. This June 7th situation was not mentioned. They asked the state. She didn't say, oh yeah, we also had one on the 7th. But as Max Shard explained, this provides the context for what happened on the 10th, which we've had that transcript for a bit. They were clearly getting together to figure out how they were going to get around Melnick representing Copeland in a way that they didn't think represented his best interest. I don't believe she mentioned it because I was watching too, but bottom line is she told the court that she didn't think that he was represented. They waited until Melnick went out of town. They took advantage of him having a new attorney the next week. But we see the setup. The judge says, what can I do? There must have been some kind of communication over the weekend between her saying, do your homework, and Monday having another ex parte meeting. What could they do? They could have another ex parte meeting and try to threaten Copeland into testifying. Adrienne Love is talking about how she cares, just the idea of someone sitting in jail throughout this trial, if that's what he's being counseled to do, that's just wrong. All of a sudden, she cares about people being in jail pending trial. And this is actually something that kind of bothered me today with Judge Whitaker, too. They're concerned, Judge Glanville and Judge Whitaker are concerned about outside agitators and there's no, I was sitting in the courtroom today. There's no agitation. There are so many limits on who can come in the courtroom. You have to put your phone away. Even if you're a lawyer, I'm not allowed to have my phone out. It's a public courtroom. They forget that I understand that it's the state's choice to try 6 people at the same time. Some, high profile defendants, but they're acting like, it's a case of public interest, which is why people are interested. And they're kind of like making it seem like everybody wants to get in because they want the attention from it. This thing's been going on for like a year and a half.
All right, let me show you. Let me play a video, Rachel, and I want to talk to you about it on the other side.
After months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right. Well,
Okay, we don't do trial by ambush. We're supposed to be entitled to have discovery. That means everything that the other side has, and there's certain rules about it. But under Georgia law, prosecutors are they don't really have to give you anything until 10 days before trial, if you can believe it. But if you have a judge gives like a scheduling order and they say that, all right, you want to have this turned over by this time and so on and so forth, judges can do that. And if this were a civil case where only somebody's money was at stake, then that evidence can be excluded. But in a criminal trial, they let everything in, even if it comes in late. And you don't have any depositions. They can't depose these witnesses. If Rachel crashes her car into mine tomorrow and we sue each other, we can force each other to go to our lawyers' offices and give a deposition under oath about why Rachel ran the red light or whatever, or why I didn't run the red light. Of course, I would never run a red light.
It's probably me. No, I didn't.
But you don't get that kind of discovery in a criminal case, and that's part of what Doug was frustrated about. Rachel, what is your take on that?
I was telling Doug's client's mother, I was sitting outside with her today. What I love about Doug is that he really I think he has a very good like compass as it relates to what's fair and what justice means. And as somebody, you know, I think when you practice criminal law for a long period of time, you kind of become jaded. You kind of just expect this, the law doesn't matter. I always joke that the way that the state like argues, if that's how they answered the question on the law exam, they would, you know, do very poorly. But in court, when you have judges that don't really care about fairness, the law doesn't even matter. And you just watch your client's rights, you watch the law just be completely watered down such that like your rights don't matter. And Doug just does an amazing job both in writing and in oral advocacy of presenting to the court the reasons why it's so unfair, like reorienting everyone to what's real. He's the best. And the judge did mention, this is what bothers me too. I like this judge more to handle this case than Glanville, but I will say, there's no real teeth to her, you know, her bites at the state. She talks about how she doesn't want this to be a trial by ambush. So Doug did phenomenal today. Bruce Harvey made a motion to exclude all statements that the state was intending to bring in by co-conspirators, meaning people who were not charged in the indictment as defendants, but who they believe are co-conspirators. Apparently, in November of 2023, Judge Glanville ordered the state to actually list for the defense all of the statements, jail calls, wiretaps, all of that they were going to be using potentially in this case, in their case in chief. They presented, I believe, three statements. Today, Bruce Harvey said, if there's anything else that they're going to try to bring in, it should be excluded. The judge said, well, you know, the state, how many other statements do you expect to bring in? And I don't know the guy's name who sits between Miss Love and Miss Hilton, but he gets up and he's like, well, you know, if I had a ballpark, it'd be at least 50.
Oh my gosh.
50 other statements. And that's just within, I believe, one wiretap.
We're going to be here until 2027, it sounds like.
That is trial by ambush. The problem is, it's like 50 statements. Yes, they turned it basically, in this case, there is voluminous discovery, meaning hundreds and hundreds and hundreds of jail calls. And what the state likes to do, this is one of her war strategies, is that she likes to basically dump discovery on you and then not tell you what she's planning on using, so that you're kind of unprepared. Every time I talk about her, my dog says, yeah. That's what's going on over here.
Well, let's go ahead. Let's finish that thought. Then I want to raise another one.
Yeah. So now the judge is basically saying, and Bruce, the good thing about this judge too, is that she really likes Bruce Harvey. I think she really likes Doug Weinstein. She really likes Brian Steele. So when they talk, she does a lot of like giggling. I think it's kind of nervous giggling, but she does seem to listen to them. And it made me feel better, because when Bruce was explaining this to her, she kind of looks over at the state like, I mean, what do you mean? The judge told you to do this. This is what the state is used to. They're used to being ordered to do things, then they don't have to do them, and then there's no consequences.
No consequences.